I'm not going to make a determination, sir, whether you're a sovereign citizen or not. It's not relevant to my determination how you characterize who you are. So if you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. If I let them withdraw, they are gone from this case. Do you understand that?
I think I will probably be better served representing myself.
And Judge Darrow did allow Brooks to represent himself. Now, he may look back on that decision and say that probably wasn't the best choice. But what was fascinating is that Brooks identifies as a sovereign citizen. This is someone who doesn't really believe that they are under the jurisdiction of the government, that they're exempt from U.S. laws, which is seemingly why he would make repeated statements about his legal name, or statements that would undermine the authority of the court and the trial.
Sir, did you hear me tell you about the penalties for these offenses just now?
I don't understand the nature and cause of the charges.
I'm not asking you that, sir. Did you hear me advise you of the penalties for hit and run resulting in death?
I don't understand.
Mr. Brooks, any questions for this witness?
Yes, I do. For the record, I don't consent to that name. Are we going to address subject matter jurisdiction?
The written decision that I previously entered is what I will stand on. I'm not going to address it any further.
Is that verified proof? Can we address subject matter jurisdiction and still has to be proven for the record?
I decline to do so.
Ah, yes, the infamous subject matter jurisdiction argument that he made throughout the trial, even till the very end. And it's an issue that really has no basis in law, because this court does, in fact, have the jurisdiction to handle this criminal case. But as the trial progressed, Brooks became even more argumentative and would constantly interrupt the judge, to the point that he would get kicked out of court and placed in a neighboring courtroom with audio and visual tools so he could see and hear everything. But it was intense and bizarre nonetheless.
Before, I need to make a record that at 8:42 a.m., this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. You can see that he is seated with his back to the court, or to the camera.
Oh boy, hey. So this one, they put him in a neighboring room. It gotta be. Cause it looked like, yeah, he in a room by himself.
Before, I need to make a record that at 8:42 a.m., this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. You can see that he is seated with his back to the court, or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items.
Yeah, and that's just the beginning of it. So we're going to get more into Brooks's behavior in a minute, but let's get into the meat of the case.
Throw and break items. They said, my boy.
What this case is really about.
Right.
We want to get into the actual crimes here. So several witnesses to this parade attack actually testified in graphic detail about what they saw and about what they heard.
Most people do not realize they could be owed a major cash payout if they have been in a car accident within the last year. Yes, that's right. If you
So then you said you heard something?
Oh yeah, you heard. I heard and saw the impact.
Tell us about
If you
that,
ever
please.
heard a car hit another car, or an abutment, or a deer. If anybody's ever hit a deer with their car, you've heard it.
He talking about the impact, because this guy hit, was it 4 people?
I watched the body fly up onto the hood, and her head snapped back, and the body remained on the hood as it passed the side of my vehicle to where I thought I could have just reached out and grabbed her.
So this happened that close to you?
Yes.
You saw all this with your own two eyes?
Yes.
Did the car continue past you?
Yes.
Where did it go?
The car veered kind of in front of me. I saw brake lights and saw what was Jane fall off the hood. He proceeded to, and she was basically on the right side of his vehicle, and he proceeded to run her over with the right front tire, then the right rear tire, and at that point I was just focused on.
So the front and the rear tires. But he's saying it like it just went one side.
On the body on the ground, but I remember hearing the roar of the engine again.
Did you see the red SUV strike any people in the Catholic community group?
Several.
Can you estimate how many?
At least 15.
Okay. And did,
What?
I'm sorry.
What? Hold on. Let's make sure. I
On
want to get this right.
the body on the ground, but I remember hearing the roar of the engine again.
Did you see the red SUV strike any people in the Catholic community group?
Several.
Several.
Can you estimate how many?
At least 15.
15.
Okay. And did,
15?
I'm sorry to ask it this way, but did you
Wow. I mean, the 6, I thought it was,
see anybody like actually fly or roll or tumble?
Yeah, so originally it was, I heard sounds, like thuds, and then it was in the air, like bowling pins.
Okay.
And not only is this kind
Hold on, what is she describing? She said thud, and then it was in the sky like bowling pins. They just asked her, she said the sound. So what is she
Several.
describing?
Can you estimate how many?
Listen,
At least 15.
okay, that's
Okay.
how many people there.
And did, I'm sorry to ask it this way, but did you see anybody like actually fly or roll or tumble?
Yeah, so originally it was, I heard sounds,
Okay, sound.
like thuds,
Different.
and then it was in the air, like bowling pins.
What do she mean? Bowling pins in the air. People?
And not only
So
is
they're
this
asking
kind of
people flying.
incredible to have a murder case, to actually have eyewitnesses to a crime, let alone these many eyewitnesses, but they also were able to ID Brooks as the driver of the car.
I saw directly through the driver's window.
What did you see?
I saw a man focused on the group ahead of him.
Is that Daryl Brooks that you saw?
Yes.
Do you see the driver of the red SUV in the courtroom here today, Officer Schneider?
Objection, hearsay.
Overruled.
Hearsay. What? What? Hearsay? Hey, one man objected, said objection, hearsay. Hearsay?
May I answer?
I'd ask Mr. Brooks be directed to remove his mask so that Officer Schneider can identify him, please.
Objection, I never heard an answer to the question.
It has not been answered, Mr. Brooks. Please remove your mask. Thank you.
Officer Schneider, is the driver of the red SUV that you've just described for this jury present in this courtroom today?
Objection,
Yes.
hearsay.
Can you please point him out by
Oh,
where
he
he's
the one
seated
saying
and what he's wearing?
I forgot he is doing representing himself. Man, this case is deep. 15 people. He represented himself. He said objection, hearsay. He keeps saying it.
He is seated over here at the table wearing a gray suit.
That's the man you saw driving the red SUV as it sped past you?
Yes, it is.
And as strong as that was, it's not even the only evidence the prosecution laid out. They also showed the defendant's police interrogation tape. You see, after Brooks drove his car into the parade, police were alerted to a man going door to door to try to get help from people seemingly trying to evade law enforcement. Well, he eventually was arrested, and he was.
No, you didn't. You looked for assistance. You looked for assistance. Hey, you putting out an SOS. I need help after you done hit 15. 15. Buddy wicked. Hey, you wicked. Look at it, and it's on him. You wicked kid.
Was brought in for an interrogation, and in this interview, the investigators don't initially ask him about the parade. Instead, they make
He was in interrogation, so they asked him about something else, and he mentioned the parade. It sounded like that's what they finna say. Let me back it up so you can hear what all we.
law enforcement. Well, he eventually was arrested, and he was brought in for an interrogation. And in this interview, the investigators don't initially ask him about the parade. Instead, they make it seem like it's just about a domestic violence incident that he was involved in. You see, prosecutors would say that Brooks actually got into a fight and attacked his ex-girlfriend, Erica.
Everyone knows you need a lawyer after a car accident injury. But what if I told you there's a better way? One, it gets you more money in 30 seconds without the 40% lawyer fees. Let me show you something that's changing everything. This is a Case Connect compensation calculator. It's powered by Harvard-level AI technology and it analyzes over 100,000 accident settlements to determine your case value. Here's why this matters.
Patterson before driving the car into the parade, and maybe he ended up doing what he did out of anger. You know, the motive has never really been clear here about why he did, but maybe it had to do with the fight with Erica Patterson. Well,
so he didn't win Jack in the Box after a fight with his girl. He didn't went and ran over 15 people. 15. He murdered a few of them. I don't know how many. But they put emphasis on it's 15. She seen flew in the air that he hit.
just listen to Brooks's reaction when he realizes what's really going on.
We been cool, man, the whole time. If I did something wrong,
that's why they were here. But do you see them here today? They're not here today.
Yeah, but y'all lied to me, man. You made it seem like they just come for no reason.
Well, here's the thing, Darrell.
And I'm like, what if it's
listen to me for a minute. I can give you a clean slate here.
I apologize.
Because you have lied to us as well. Because you came out here in the red Ford Escape. Okay, that is what you came out here in. You had the key. Alright? So what I want to do is try to give us all a chance to reset. You understand what I'm saying? Start over. Because you're not giving us an accurate story.
What if it wasn't me driving? What if it wasn't you? What if it was my mom's truck? Mm-hmm. But I wasn't driving. Mm-hmm.
It's a mom's truck, but you weren't driving. What that mean? Your mom's was with you. What he claiming his mom's was driving and ran into them people. Not him. It's his mom's truck. So mom's was driving and you were in it. That's how you were there with the truck. That's how you got the key. So what your mama that took off from the scene. Let's see what he say, man.
What
did he say? That sounds like what that's
mm-hmm. Who else would it be? That's what I'm asking. Not me.
That's not you.
That's not me.
That's not you.
No, I don't.
Darrell.
That's
Darrell.
Hey, that's you.
That's you, Darrell.
Why you say it like that, man?
Oh, right. He
say, why he saying it like that? Hey, what he showing him? He said, that's you, Darrell.
That's what I'm asking. Not me.
That's not you.
That's not me.
That's not you.
On the phone.
Darrell. That's
Darrell.
Hey, that's you.
That's you, Darrell.
Why you say it like that?
Something. Some camera footage or something.
That's Darrell.
Something. That's something.
Hey, that's you.
That's you, Darrell.
On that phone. Some picture, camera footage.
Why you say it like that, man?
Oh, right. He wasn't driving, but what happens if he knows who was? Right, yeah, that's what makes sense here. Suspicious behavior? I would say so. He seems more concerned with the tactics that police use than really giving them good explanations. Now, Brooks, like I said, represented himself throughout the course of this trial. And to give you a sense, this is where he went when he cross-examined the state's witnesses. You can kind of see his defense.
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
I've been driving a long time, and a lot of times people get angry, they're late, they beep their horn at you in a way that is because they're upset and they're trying to get past you.
Oh, yeah. That's accurate.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
He just asked you the same question again. Yeah.
I assume that he was.
This isn't a hard drive.
Hey, buddy. Buddy, wicked, boy.
This little box does
Wicked.
so much more. Amber X is a personal
Dang.
cloud. It has all the same features as iCloud,
That's a lot
Google
to
Docs,
fathom
and
right there.
Dropbox.
You thought because of that sound that there had to be some mechanical problems going on with the engine.
I thought that there could be.
But it was your first initial thought, correct?
Correct.
And you were able to hear that sound and come to a conclusion that possibly there were mechanical issues all in a few seconds.
A lot runs through your mind at that point in time, yes.
And you can see Brooks seemed to suggest a few things here. One, maybe it wasn't the intention of the driver to hit anyone. Maybe he was honking to get people out of the way. And two, maybe there was a mechanical issue with the SUV and the driver lost control.
Nice defense. Nice defense. You know what I mean? Coming running, trying to get the field goal. Them steps, how you... Yeah. The defense. Both sides of the field. It's like a defensive game. Trying to stop from getting hit. Trying to stop something from going through to make the goal. Yeah.
The only problem with that is that a state inspector testified to the complete opposite. He reviewed the steering wheel, the tires, the brakes, the gas pedals, and said that there was no mechanical issue. That the
Why would they expect a car? You come up with something like that. Wow. They refuted that. Hey, ain't nothing wrong with this car, buddy. We done tested it. Yeah, something wrong with the driver. Something wrong with the driver.
driver would have lost control. And also, even putting that aside, the honking, if you honk, but you didn't stop, what does it matter? That's the point. He drove the car. He didn't stop. He kept mowing people down. Doesn't matter if he honked. But what made this trial so different...
What is they saying, the honk? What is he saying? He honked. They should have got out the way. He's saying the car couldn't stop. That's a mechanical issue, but they refuted that. So what is the honking? I guess breaking that down to his defense, you honked. People didn't move. You mowed them down. You can't do that no matter what.
Different. And so out there was the defendant's behavior as he represented himself, because he would constantly interrupt the judge and bring up these legal theories that had no basis in fact and law, and the ups and the downs with his behavior was so startling. And at one point, let's begin, after he had a few of these outbursts, he actually apologized.
I would like to issue the court an apology from me in regards to my actions last week during the trial. I just want the court to understand it's very emotional right now, not only for just the whole situation of the trial, the families here that have to go through, everything that's gonna be involved with the trial, but also my family as well and myself is very, very emotional. But not to excuse my actions, I should carry myself with better respect than that. I wasn't raised that way.
The "I wasn't raised that way" is really something else. But we all knew this didn't last long.
I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming
Man.
out.
For the jury. Not gonna work.
Yeah.
Whoa. This is... It's beyond me.
And it only got worse.
All right, so listen up. Stay
And it only got worse. Man, that's...
Farm was trying to charge me $197 for car insurance. No, thank you. I got a friend who told me about this website, and now I'm spending $58 a month.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody. That's what nobody. You don't gotta explain nothing to me.
Do you want?
That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor.
I need red.
Now, in fact, there was one point when he got so angry. You see, Brooks had called as a witness his ex-girlfriend, Erica Patterson. Now, she had previously testified for the state, and it's alleged that Brooks got into a fight with her and attacked her right before he drove the car into the parade. And Brooks, when he had her on the stand, what he wanted to do was introduce these photographs to arguably show that she wasn't a credible witness and also a bad mother. So when prosecutor Zach Witchow talked about what would happen if these photos were allowed into evidence, he said that he'd have no choice but to reveal something very negative about Brooks's past. And again, this was all outside the presence of the jury. And thank goodness, because look how Brooks blew up.
Second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
Oh, man, they cut. Now, why would they bring up her being a bad mom? What?
And that's
Furthermore,
object to that.
I'm not
because
sure.
that's a lie.
Let him
Because at the
finish.
end of the day,
Let him
if
finish,
we gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much.
Once
So
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask that question.
Over the top
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No, that's
finish.
not.
If that's the case, he could deliver that different. If that's the case, it's about the delivery. Yeah, that's nice.
I'm not
Like
going to
them
sit here and
wings.
let somebody be inaccurate on the record and lie on the record.
Little Beamer, seeing a little Beamer. It's a little sporty one. I like it. I didn't lost track of them. 350 eyes. And... Yeah, but anyway. Oh, well, am I missing something?
Over the top animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
that's not. I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what?
Yeah, he
Can
yelling.
dial that back. We're just going to take an
Why is it? Yeah. She said, so she finna take a break.
early lunch, 1 hour, we'll be back, and unless he brings that letter and he can show it is inadmissible, she will not be questioned, and under 906.11, I will declare the cross-examination closed. Thank you, we're in recess, 1 hour.
Trying to catch that. I heard her saying the cross-examination.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
And if you thought that...
So this is different. Let's see. This might be some different behavior. Look at the gesture in. Well, the camera will catch a guy talking, you know. Especially if you're a little animated with your hands. Catch you in. The still frame just, you know. They catch us all. Let's see.
That was bad. The worst of the worst is when at one point the judge had to stop court proceedings because she was actually scared of Brooks.
So as long as the jury's out, we should probably discuss.
Who? Talking to the prosecutor or the judge? Because he been coming at the judge. Gotta be the judge.
That I would like to provide the defendant and the court with.
You hear how she said defendant? Yeah, she own him. Step on it.
Actually scared of Brooks.
So as long as the jury's out, we.
Hold on,
of the worst is when at one point the judge had to stop court proceedings because she was actually scared of Brooks.
Yeah, the judge.
So as long as the jury's out, we should probably discuss that. So
Judge.
I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
Oh, he caught it.
That's not.
Oh, he caught it. Oh. Oh, man. Hold on. He caught it. Wow, that's crazy. That's crazy. So I must have stopped it right before his reply. Because when I stopped it, I didn't hear nothing from him. It was quiet. But I caught her, the defendant. He caught it. Let's hear it.
Defendant and the.
Because she was actually scared of Brooks.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be
Oh, he
said.
took a while.
The defendant.
That's not how it was said.
Man, he took a while. Hold on.
That was how I said you want.
Yeah. Hey. Buddy Carter.
Run the record back.
Mr. Brooks.
So I'm the only one. I got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom, and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescott.
that.
Stop
Yeah,
talking.
they're arguing. They're arguing instead of. It's like emotion coming out instead of the evidence. You heard the people, the witnesses.
Oh man, like I don't know who y'all be thinking y'all fooling. I
See if they're pushing the case forward still.
This document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
please-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
Now, despite all of these outbursts, the judge moved forward with the trial. She gave.
Yes. Man, I heard her say that. So he's staring at her while they reading these charges.
OWI 4th from 2003, criminal trespass to dwelling from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist.
Look at the bailiff. Look at the bailiff behind him. He got him. Hey, he got him. The bailiff behind him got him. They say he got him.
It makes me scared.
Now, despite all of these outbursts, the judge moved forward with the trial. She gave Brooks a lot of leeway. She continued to allow him to represent himself. She didn't kick him out of the court all the time, although it happened a lot. And I've said it before because a lot of people have asked, why did she do that? Well, a common theory is that she did this because she wanted to preserve the record for appeal. That if he gets convicted, an appellate court can't say that the judge acted unfairly to Brooks, that she gave him every warning, every admonishment, and the only person that torpedoed Brooks's case was Brooks himself. And that also included when the judge said to Brooks that he forfeited his right to call any more witnesses or take the stand himself because he refused to answer her questions. Now, he claimed he couldn't hear what was being said when he was in the adjacent courtroom, but an IT specialist and a bailiff testified that the volume was loud and clear. Either way, after this, after Brooks was told that he forfeited his right to present a defense, he was particularly upset.
Hi, I'm Hank Tiny Whitey's Whitman, and if you've been injured in an auto accident, I'm here to give a wedgie to insurance companies.
There's a better way to find a better attorney to...
Hey.
My final...
No, that hurt. Hold on.
And that also included when the judge said to Brooks that he forfeited his right to call any more witnesses or take the stand himself because he refused to answer her questions. Now, he claimed he couldn't hear what was being said when he was in the adjacent courtroom, but an IT specialist and a bailiff testified that the volume was loud and clear. Either way, after this, after Brooks was told that he forfeited his right to present a defense, he was particularly upset.
My final question to you, do you have any requests as it relates to the jury instructions?
Judge look good. Oh, that judge. Sheesh. Hey, she nice. Decent.
My final question to you, do you have any requests as it relates to the jury instructions?
She look, she could be anything. Italian,
he was particularly upset.
My final question to you.
Yeah, you can see it. Italian.
Do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you said.
Then you should put the headphones on.
Don't you understand? What about that don't you understand? Did you see headphones? You can see everything. You can see boxes, but do you see headphones?
Have you asked for headphones to be provided, sir?
I shouldn't have to ask for them. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated they were perhaps afraid you might break them.
Yeah, I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop.
This, I don't know if I can get through this. I done made it a long way watching this, but you see his behavior like that, and man, that's this here.
Sit up
like
here
torture.
and do everything you're doing.
I can imagine how it was for them to go through this. That's what's up? Look at you. Look at you. Hey, you got it.
Don't see what you're doing.
Baby boy, you got it.
You ought to be ashamed of yourself.
Zeus.
Talking to a judge, it's just shocking. Well, with him forfeiting his right to present a further defense, the trial headed for the end a lot.
Talk to a judge like that. I'm thinking about how annoying it could be, just him, period, just having to deal with him. But this is a judge. He talked to a judge like this.
Sooner than we anticipated.
Wicked.
I mean, it would have been really something and very interesting to have Darrell Brooks testify, take the stand, and particularly be cross-examined. But Alas, it was not meant to be, and given his noncompliance, we move forward with the closing arguments. This is the last attempt in closing arguments for both sides to persuade this jury to vote a certain way. Closing arguments are not evidence. They're basically a summation of the case. First up, prosecutor Sue Opper.
He had plenty of opportunity to just...
Oh, yeah, she definitely gonna push. She pushing that case forward. She done work some cases.
Stop. Anywhere along the way, one of the officers testified to it. I think it was Officer Schneider. If this was an accident and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route at any point, all he had to do was stop.
Man, I want to see what she talking about passing all this. Because obviously got his
They
course.
could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks.
He could have stopped and just turned around. What's the problem? You're going to a parade. What you got to get to it? You could have went around. Nah. It ain't that deep.
It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional.
Buddy wicked. Push through a parade. Push right on up to it. Here.
He plowed through 68 different people. 68.
What?
How can you hit 1 and keep going?
Hold on,
How can you hit 2 and
hold on.
8 different?
I know you ain't saying he hit 68 people. Ain't no
30
way.
miles an hour.
Ain't no way. Ain't no way. She better be saying 6'2", 6'2", 8 people. But they had no exact. I know she ain't saying no 68.
That's intentional.
Listen to this.
He plowed through 68 different people. 68.
I know. 68 people. Ain't no way. Nah. And this is like 2 years ago. Ain't nobody never heard of this. He hit 68 people. 68. This should be national news.
He plowed through 68 different people. 68. How can you hit 1 and keep going?
68.
How can you hit 2 and keep going? How can you hit 3?
Man, I felt that. She said, how could you hit 1 and keep going? How could you hit 2? You hit 68 people? Bro, man, there should be people.
3 and keep going. Didn't phase him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's intentional.
Again, she's really focused.
You should fry. Like, put him in the grease.
On the intent here. She's focusing on the 6 counts of first-degree intentional homicide in particular, and that if you had any question about what he was doing, just look at his actions. But Brooks had a response. A defendant or a defense attorney can present a closing argument. Obviously, he's representing himself, and he presented the closing argument, and he went into areas that he really wasn't allowed to go, though.
You should be informed that
Look at the prosecutor.
you have the power
District attorney.
to nullify any law that you don't agree with.
Objection. Move to strike misstatement.
Sustain.
Objection.
What? Oh.
I will strike from the record the last statement made by the defendant.
Let's see it. Going the right direction. Okay, yeah.
Intentional homicide in particular, and that if you had any question about what he was doing, just look at his actions. But Brooks had a response. A defendant or a defense attorney can present a closing argument. Obviously, he's representing himself, and he presented the closing argument, and he went into areas that he really wasn't allowed to go, though.
You should be informed that you have the power to nullify any law that you don't agree with.
Objection. Move to strike misstatement.
Sustain.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. But the fact of the matter is, the vehicle in question, make and model of 2010 Ford Escape, was in fact.
Hold on.
Recall.
Objection.
What did he say?
Actually, 2008, 2009, and 2010 of that model was in fact recalled.
Objection. Misstatement of the facts. Facts not in evidence.
Was in fact.
Improper argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford.
Objection.
For those
Facts not in
models,
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to.
He going back with the defense. Well, I ain't gonna say going back, because they said that was his defense, that something was wrong with the car. They said they had the car inspected. He's saying that, like, they ain't privy to the fact that that make and model had recall and it messed up, it malfunctioned. That's why he hit all them people.
That you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies.
Mr. Brooks, move out.
There's a driver from a small town.
They told him to move on. What?
In Texas, who walked away with $80,000 after their car accident last month. Here's the shocking part. They didn't win the lottery, they didn't inherit a dime, and they never dealt with shady insurance companies.
Okay, so first, a defendant can't argue jury nullification. Jury nullification is when a jury decides a case not based on the facts and the law, but some other reason, political, emotional. They're not allowed to do that. And that's what Brooks is basically advocating for here. He's basically saying, even if the prosecution proved beyond a reasonable doubt that he's guilty, you, jury, have the power to say otherwise. You can say not guilty. And this is despite objections from the prosecution and an order from the court telling him not to do it. He kept saying it. And by the way, the idea of a malfunctioning car, as we discussed, not only was there no evidence to suggest that wasn't even the case, but you can't argue something that wasn't presented in evidence. There was no evidence presented at trial about a recall or a class action, so all of this was irrelevant. Well, the jury was ultimately handed the case, and after about 3 hours and 15 minutes, the jury came back with their verdict.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intent.
So, hold on. Where's the jury? Is the jury not present? Like, is they not present? Why she got a paper?
Intentional homicide as charged in count 1 of the information. Dated this 26th day of October 2022, signed by the foreperson.
Burn in hell, you piece of shit.
Hey, you are to be removed right now.
Ooh. Hey, yeah, feel the fire. That's what I'm like, man, ain't nobody there like want to get him?
With their verdict.
We, the jury, find the defendant, Daryl E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. Dated this 26th day of October 2022, signed by the foreperson.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not...
He said, hold on. But he said...
Dated this 26th day of October 2022, signed by the foreperson.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not...
Hey, buddy only... Hey, buddy only... He get kind of paranoid too, and look, like you look... kind of sneaking, trying to see like over his shoulder a little bit, little peripheral, you know what I mean? Let's
not do that.
There you have it. They found him guilty across the board of all 76 charges, including 6 counts of first-degree intentional homicide, which carry a mandatory sentence of life in prison. And at the time of this recording, the sentencing date hasn't been set yet, but we believe that the victims' family members, they're all going to have an opportunity to make statements, and also Mr. Brooks and anyone on his side can make statements as well, and we're definitely going to follow it and hopefully report on it here on Sidebar. But I do want to leave you with this before we go. As much as this trial and the attention to this trial focused on the actions and behavior of the defendant.
Oh, yeah. I'm glad he finna do this, man. Woo! 68. That's only 6. That's only 6.
Here on Sidebar. But I do want to leave you with this before we go. As much as this trial and the attention to this trial focused on the actions and behavior of the defendant, we can't forget what this case is really about, and that is the victims, and particularly the 6 people who were killed in this nonsensical tragedy.
Okay,
and that's
so
all we have for you,
69.
everybody. Thanks so much for joining us here on Sidebar. Please subscribe.
Okay. So that's the case. He hit 68, but 6 died.
On Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. We'll speak to you next time.
That was a good one.
Here on Sidebar, please subscribe on Apple Podcasts.
That was a good one. Definitely a goodie. A goodie. A goodie cook. A goodie cook. Cook something up. I went to that same shop. I went live when I watched that.
Rap superstar Lil Durk locked up right now, accused of ordering a hit on a rival rapper, but his defense says the government's only proof that Durk was involved is based on a random video they found on YouTube. And now they brought in music producers who've worked with Durk, and it might just blow up the whole case. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Did Chicago rapper Dirk Banks, also known as Lil Durk, orchestrate?
I just picked up something. You know, I guess I'm just going. Look at Dirk holding that Grammy. Lil Durk.
A murder for hire plot against Quando Rondo that ended with the rival's cousin dead and multiple people caught up in the conspiracy? Well, that's what the government's alleging, and they point to Dirk's own song lyrics as proof of his alleged actions. That's what we want to focus on, because the defense says there is a big problem.
So you're going to focus on a song? That's what they focus on? That's crazy.
2021. And in his statement, he writes, on January 25th, 2022, I had a recording session with Mr. Banks where we recorded the song Wonderful Wayne and Jackie Boy, which at the time we called Too Toxic. I loaded the song up around 5:39 p.m. Mr. Banks then wrote the verse right there in the studio, and we recorded the song and finished in less than an hour. Once we recorded the song, I bounced out a rough draft, saved a copy in audio format, and named it Toxic Babyface featuring Lil Durk at 6:33 p.m. After that, we continued with the rest of the session. And now remember, the shooting at the California gas station happened months later on August 19, 2022. So the motion includes a second sworn statement, this one from a music producer and audio engineer named Ahmad Sharif. He says, I received Dirk Banks' verse and lyrics for Wonderful Wayne and Jackie Boy from Justin Gibson on July 22nd, 2022, so the month before. After July 22nd, 2022, I received no other additional lyrics or modifications to the original lyrics from Dirk or anyone in Dirk's camp. And Sheriff then talks about the apparent edits to the song, which includes Quando Rondo screaming, no, no. I have reviewed certain YouTube links concerning the song Wonderful Wayne and Jackie Boy. As a producer and audio engineer who worked on Wonderful Wayne and Jackie Boy, I can confirm that the audio and video clips feature typically for social media platforms.
Oh boy, you got What? That don't prove nothing though. They saying the number 10 said the video clips featuring audio of an individual yelling no, reportedly from a news clip, are not from the original recording as referred in paragraph 8. So that don't mean nothing.
Yelling no, reportedly from a news clip, are not from the original recording. These clips appear to be fan edits, specifically for social media platforms such as TikTok, and are altered, fabricated, and inauthentic versions of the song. Joe, it's a pretty good argument from the defense. Again, if that's true, prosecution didn't figure that out?
Yeah, and you don't even know whether or not what you used actually came from the artist. That's one of the big points that they're making here, is that there were things that were edited later, and that's why it's so much more important for us to understand what the presentation actually was to the grand jury, because actually did in the studio. They probably showed. That's why it's so much more important for us to understand what the presentation actually was to the grand jury, because demonstrably we could actually probably.
This mug used to light up. They don't do that no more.
There's another reason there that this has ended up being a problem.
Now, I will tell you, I mean, in today's day and age, it's hard to know what's authentic. I see a movie trailer, it looks like the real thing. It was a fan page. AI? Oh my gosh. You think this is going to be the end of the problem? Now, in the conclusion of this filing, the defense says, a prosecutor who knowingly secures an indictment based upon false information, or who allows a falsely obtained indictment to persist, routes the grand jury from its central protective function. That is clearly what happened here. For the foregoing reasons, the court should dismiss the superseding indictment against Mr. Banks. In the alternative, the court should compel disclosure of the relevant underlying grand jury proceedings. Joe, how's this going to shake out? You think the court is going to agree, dismiss the indictment? Could they refile it without the lyrics? Do you think the prosecution is going to fight back at it? Because I'll tell you, at last check, we checked the federal court records, and as of this recording on Tuesday morning, neither the judge nor the prosecution has responded to this motion to dismiss. So how's this going to all shake out in the end?
I would think that the defense is going to get one or the other. one being either dismissal of the indictment or a compelling of a review of the transcript so that they can know. I mean, they've got some pretty good notions. Those declarations under penalty of perjury, of course, would tend to suggest very strongly that what came out and what they are using is not, it happened, was done many months prior to the actual killing, and that it might be even in a different form what Lil Durk actually did versus what was actually released and possibly used. Under those circumstances, I think you gotta do something so that you preserve the integrity of the grand jury process. So the defense is hoping for that. In a case like this, based on these particular facts, I think one or the other ought to happen.
Joe Richardson.
Don't seem like they got none. As far as that aspect, when it comes to the music thing, they refusing that.
Man, I love having you on. Thank you so much for taking the time. It was great seeing you, and we'll see what happens next.
It's going to be crazy. Thanks much, Jesse. You guys be good.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next.